really what I'm going to be talking about today is, this evening, is an overview of issues in the area of mediation. And of course, my perspective is not that of a mediator. I know many of you have a great deal of experience, but really it's a theoretical perspective. And I know there's always an issue because it is said that in theory, there's no difference between theory and practice, but in practice there is. So that will be an issue, and certainly I'll be going over many issues, and some of them will be going, many of them, in fact, all of them will be going into more depth over the next 3 days. So you'll forgive me if it's not as deep a treatment as you might want. I've been asked to talk a little bit about the history of mediation in Canada in particular, and looking back not just over the last 25 years, but before that as well, and talk about some, or at least identify some of the current issues in terms of policy and practice. And one of my themes here is this is a definition of family mediation, and there are a number. This is by Howard Irving, who of course is one of the founders of family mediation in Canada and internationally. He wrote a book which I'll talk about in a moment, and his definition is family mediation is a process in which an impartial third party helps separated families to identify and clarify issues between them and assist them in coming to an agreement on some or all of those issues. Now, many of you identify yourselves as family mediators, and we might say that's your primary role, but there are many others here who engage in family mediation. And so I would include, at least in some senses, lawyers, judges, assessors as people who help separated families identify issues and resolve cases. So it's not just those who would identify as mediators, it's a much broader spectrum. And that'll be one of my themes this evening. And in a very broad way, this conference, I think, is appropriately designed to, and intend to encourage discussion about mediation, and at least from my perspective, encourage more use of mediation in Canada. However, that doesn't mean that mediation should totally replace the court system. While I think it's important to encourage and educate and counsel separated parents and separated spouses to make use of mediation in appropriate cases, it's also important to be aware of the limitations of mediation and to recognize the role of the courts. One idea which I'll talk about a little bit, I think will come out more in the next couple of days, is that often judges have a role as mediators. And indeed, one of the things is I think we should be training judges to be better at mediation. And indeed, when we're appointing people, at least the family court bench, they should be aware of the fact that that will be part of their job and have those kind of qualifications. And we also have to recognize that there's a role for the court system per se, that we, at least in our society, if we're going to be making orders for people to do things, it's judges who should be making those decisions, and mediation may not be appropriate. So I've identified some issues here, certainly cases where there's very high conflict, and it's not one or the other. Certainly there are conflict cases where mediation will work, but at some point it's not going to be appropriate for mediation. There are issues of domestic violence, and again, at least for me, domestic violence is a complex and nuanced issue. There are cases of domestic violence where it may be appropriate to have mediation, but it's also appropriate to recognize there are cases where it's not. Similarly, there are issues of alienation, something we'll talk about. There are cases where one parent is undermining the other parent, where it's not going to be appropriate or possible to have mediation. There are cases where someone is being dishonest and not open, particularly if they're hiding financial or other assets. It's not going to be appropriate to have mediation. So one of my themes really is that that mediation has a role, the justice system has a role, and it's important to try to improve the coordination and information flow and interrelationship between those institutions, and indeed a range of other institutions and agencies and professionals in between as well. I think you're all aware of why we have mediation and what its value is, but I'll talk about this very briefly. Certainly, the ideas behind mediation developed because it was recognized that there are real limits to the adversarial system, and indeed the traditional litigation-based approach to family law is often inadequate and doesn't meet the needs of parents, and in particular, is often counterproductive for children. And so we are seeing, I think, in our society, and not just in Canada, but internationally, a broad move away from, or at least limitations to, the court process, and saying, let's see if we can resolve cases outside the court system. And if we're talking about young offenders, it's alternative measures or extrajudicial sanctions. If we're talking about the civil litigation process, there's now, in some provinces, there's a mediation process or mandatory attempt at civil mediation. So we're broadening out. And we also recognize lawyers, I think, are changing how they practice family law. At least I'd say good family lawyers are changing how they practice. They recognize there's a role for litigation, but some of them are involved in collaborative family law. And to me, collaborative family law is a kind of, has mediative elements to it as well. And we are realizing that the ultimate issue in a family law situation is to help the parents restructure their relationship, to go from being partners and spouses to being co-parents, and recognizing that mediation can often play an important role in that education and change process. And recognizing that family law cases are not only about the law, but they're often about, and in fact more about, the issues of emotion, social reality, psychosocial relationships. And helping people address and understand those issues is a critical part of the process, and mediation is more likely to do that than a litigation process. Not to say that litigation doesn't have a role, but people are to be helped to have a restructured relationship and to recognize that it's going to be a permanent relationship. They're not going to get rid of each other. I don't practice family law, although many, many years ago I did a little bit. And you know, one of the things about family law that I would tell people, and tell people now, get in touch, is you don't really know someone until you divorce them. And you know, the reality is that people think, I'm divorced or I'm separated, that's it. No, you're divorced, you're separated, but your relationship, if you've had children, will never end. And you have to learn how to restructure and deal with it in that context. Certainly in some contexts, mediation can be faster, less expensive, and certainly and a major focus here is it may well produce better outcomes for children as it helps parents to have a better relationship between them and better understand the needs of their children. It's certainly something I'll come back to. And the hope and recognition is that parents in our traditional litigation, or indeed legal model, people have a dispute, they have lawyers, they come to court, the judge makes the decision, and that's the end of it. And indeed, in many contexts, for many kinds of cases, that's true. But in family law cases, the court process or a judgment is not the end of it, it's just a stage, and the relationship is going to go on, and mediation can often give people better tools for dealing with that relationship in the future and dealing with the changes that are inevitably going to occur. So if people have children, it's not once and for all, quite to the contrary, it's going to go on. Circumstances will always change, the children will get older, economic circumstances will change, and the relationship between the two parents will have to change as well. Now, in terms of the history of mediation, it's interesting that you had your conference in 1988. If you look back, that's about halfway, we were about halfway through a process, and I think the history of mediation can be traced back, at least in Canada, in a formal sense back to the 1968 Divorce Act. The 1968 Divorce Act recognized for the first time in Canada no-fault divorce. Prior to 1968, the only way you could get a divorce was by showing that there was an innocent party and a guilty party. And in Quebec, by the way, of course, even more difficult, you had to petition Parliament. But it was very much a fault-based system. Starting in the late 1960s and influenced by the United States and other places, people began to recognize that marriages could end, and it's not necessarily the fault of one party. And that was reflected in the Divorce Act. The 1968 Act actually allowed for judges to make a referral and order that people go to marriage counseling to try to save the marriage. There's certainly a role, I think, for obviously trying to help people to preserve a relationship if they reasonably can. I think that by the time people come to court and getting a divorce, it's probably pretty late to be making an order for marriage counseling or direction for marriage counseling. The first mediation programs in Canada were set up in the 1970s. Actually, in Kingston, Ontario, where I live, was one of the first programs. In Toronto, out west in Hamilton. There were a number of programs set up in different cities, often set up through nonprofit agencies with some role for government, and gradually there were also private mediators going into practice as well. I understand in Montreal the first mediation program was set up in 1981, a little later than some other provinces, but I think, and this is something I'll come back to, Quebec probably has the most well-established mediation program in Canada right now. In the 1970s, 1980s, we gradually began to see an extension of mediation across Canada, recognition in different family legislation that there is a role for mediation. In some provinces, the rules of family court were changed to allow judges to make orders, or at least referrals for mediation. And in 1985, Family Mediation Canada was established. I know there are members here, Tom Dart, and others who've been very involved in Family Mediation Canada, and there are other similar organizations at the provincial level. The 1985 Divorce Act came into force in 1986, changed the grounds for divorce, again moved to a more of a no-fault regime with 1 year separation being the primary ground, I think, now for almost all divorce in Canada. And also a recognition, at the time the Divorce Act was coming into effect, there was a lot of discussion and controversy. People were advocating that there should be a presumption of joint custody. That was not in that act. People were advocating, and we'll come back and talk about this, to have mandatory mediation. That was not put in there. But the government had put in a fairly weak statement saying that it's an obligation of a lawyer who is involved in representing a party who's getting a divorce to inform that person about the advantages of negotiating an agreement to resolve various matters, and to inform the person who is there as a client about any known local mediation services. There was no requirement that mediation services would be established, and the lawyer could always say, well, I didn't know about mediation. And indeed, there's a really good question about how effective that provision is, but it was a recognition, at least to some extent, by the federal government of the value of having mediation. And indeed, since then, I'm going to talk about this more in a little bit of detail, and then tomorrow we're going to have a number of presentations. Since then, really across Canada, from coast to coast to coast, we have some kind of mediation in every province that is in some ways either encouraged by the government, subsidized by the government, or organized in some way by the government. Certainly, now we have information programs, and again, varying certainly across the country, but information programs where parents are either encouraged to attend or required to attend, and informed about the value of mediation. In Ontario, for example, we have the so-called mandatory information program that deals quite extensively with issues around mediation. I say quite extensively. In Ontario, it's a 2-hour program. It's interesting, I actually had some students who did a study about, two of my law students who did a study in Kingston about the mandatory information program, and it turned out, well, there were a couple of things, of course. I mean, we call it mandatory information. It turns out only about 75% of people go. And you can say, what's mandatory? Well, they don't go. The judge lets them come into court anyway. And one of the reasons that we did the study was lawyers were saying, my client shouldn't have to go. I've already spent time talking to them and educating them. They shouldn't have to go to mandatory information. It should be there for people who don't have lawyers, and of course there are many of them. It turned out that the people who get more out of the 2-hour education program, people who already have lawyers. And we sort of delved into that a little bit, and the reality is there's so much compressed into 2 hours. They've already had the education from the first lecture from their lawyer, and then they go and they get more out of the information program. The people who don't have lawyers and haven't heard of this all, they're just overwhelmed by the information. And when I think about that as a teacher of adults, I mean, I just told my students, this is it, I'll give you the whole course in 2 hours, write the exam. They'd be overwhelmed. They'd say, no, we're going to go through this very slowly. We're going to repeat the main ideas. And so I think that's, one of the ideas is people have to hear the same thing many times. And that's certainly true about the value of mediation. I think sometimes people say, well, if we tell them once and they don't go, that's enough. I think that's not. People have to repeat it. Some people have to hear the message many times. Now, as mediation was being developed, Howard Irving, of course, and a huge pioneer in this country, wrote a book, Family Mediation, The Rational Alternative. And it's a very important book, and it certainly encouraged mediation. I think it's appropriate. One of the I think, though, in some ways he oversold it. First of all, I call it the rational alternative. I would say mediation is a rational alternative. There are a number of others, depending on family circumstances. Yes, there's mediation, but for some families, it's going to be better to go to an assessment with a psychologist. For other families, it's going to be collaborative family law. So it's one rational alternative. The other important point is that it may be a rational alternative, but many family litigants are not rational. And indeed, I think, Phil Epstein, among others, has said, well, if we look at the population as a whole, about 10% of cases end up going to litigation. And if you look at the population, about 10% of the population is personality disordered. It's probably not a coincidence that those two numbers are the same. And I think that we have to recognize there's some people who are not behaving rationally, particularly in the context of separation divorce. And we have to be really realistic about what that means. At the same time as mediation was getting going, there developed a critique of mediation, or a set of critiques of mediation. I think the strongest critiques of mediation probably come from feminists, although there are others. And there's a huge gender issue underlying a lot of family law. And certainly in this area, it's true. One of the critiques of mediation has come from and continues to come from feminist scholars who in some contexts, and I want to say feminism like Christianity, there are a lot of different people out there who have a lot of different views. There are many people who would identify as feminists who say they're very much in favor of mediation. But there's a group of feminists who either have concerns or are opposed to mediation and say they're very concerned because women might be forced to go to mediation. They might be going there if there's domestic violence in an inappropriate way. There's concern about the privatization of family justice and a suggestion that women have worse outcomes from mediation than by going through the court process. Now, I have to say that that's a critique and it has value, but I think it also has, as a critique, has real limitations. And indeed, one of the issues is when one starts to do research, and I'll talk a little bit about research in a few minutes, it's not clear that, for example, mediation is worse than court. And indeed, in Canada, we had a study done by John Richardson in the 1980s who found that women who went to mediation actually had better outcomes, in economic terms at least, which was measurable, than women who were going to court. So it's not clear. And indeed, one of the issues in this area, and I'll come back and talk about research, we don't have a lot of very good research, and what we tend to have, and I think we'll probably, with all respect, sort of see this at the conference, is people saying, well, maybe we don't have research, but I know from my experience, or I had a case, or I know somebody, and typically they'll say, like if you're a judge, you'll say, let me talk about the worst mediator I've ever heard, and then you hear a story. And if they're a mediator, they say, let me tell you about the worst case I've ever heard that went to court. Well, they won't say the worst case, but they'll start talking about some horrible case. And the reality is all professional groups have their strengths and people who are perhaps not as effective with certain kinds of cases. And there's a real concern in this case about what, and this was, I sent that PowerPoint and it was corrected. I said, this is anecdotal information. People say, oh, he means anecdotal. No, it's not anecdotal, although anecdotes in English, it's people are saying, I have an anecdote, I want to tell you a story. And we can dismiss an anecdote, but people say, no, this isn't a story, this happens a lot. And so I'm a bit of a social scientist. So, well, how much does it happen? Do we have research about this? So, for example, the issues about domestic violence and mediation, do we actually have research about women who do worse in mediation? How many of them are there? Which women do better? So we have to do more research in this area and not rely on anecdotes, or if you want, it's another way of saying personal biases. So I think on the one hand, mediation has been sort of oversold by some people, saying we should only have mediation, or we should, or it said, that family breakdown is not a legal problem, it's a social problem, so we should, get these cases out of the courts. I don't agree with that. I think there's a role for the courts. There's also a very important role for mediation. But we have to recognize that sometimes it's being oversold, and I would suggest sometimes it's also over-criticized. And indeed, from a policy point of view, and I say this with great respect to feminists, I think feminism has been, to me, one of the most important developments of the last century, and the changing role of women in society and in the family and in the economy and in politics and the judiciary and so on. And we certainly need more of it. I'm not a huge fan of our present Justice Minister, some of his comments. But there is, to me, also a group of feminists who sort of have a very strong position, particularly actually in the academy, but also in some governments, who are very, very opposed to mediation. And I think they're overstating the criticism, and I have a lot of concern that there's a very small group that has a great deal of influence. That's an issue that we can talk about in different ways. Now, having said, mediation is very valuable. it should be considered. There are also cases where it's not going to be appropriate, and we have to recognize there are cases that's not appropriate. There are cases where people are manipulating mediation and in effect saying, oh yes, let's go to mediation and we'll just run out the clock here. So if one party is in a stronger position economically, or one party perhaps has custody of the children, say, oh, let's not deal with this now, let's not go to court, let's have mediation, and we'll see. And that may really be manipulating the process, and mediators and the people who do policy have to be aware about this issue. Similarly, there are issues about disclosure of financial assets. And we're kind of going back and forth talking about mediation as regard child-related issues, mediation as regard economic issues. For economic issues, having access to information about the other party's financial affairs is extremely important, and that's not always forthcoming. Another dimension to a lot of this is economic, and who are we talking about? And this is something I'll come back talk about, and you're all implicitly aware of. We're talking about mediation for people with limited assets, limited resources, or people who have more assets, more resources, and there's a place for mediation in both those situations, but the requirements and the expectations, particularly around financial disclosure and legal advice, may be different. And also the training qualifications for a mediator. And I think that's something we have to be very candid about. If you have a lower income couple and you say, you know what, they have no significant financial assets at all, they know exactly what they have, the only issue is that they're dealing with their children, and child support, you can say, well, child support, anybody can now tell. We'll just look at the child support guidelines. It's on a computer. We can quickly resolve the economic issues, and someone without legal training may be a very effective mediator. There may be other cases where there are more complex financial matters. They have more assets. You may say the person who should be mediating at least the economic issues needs to have understanding of the legal and tax and other implications. One of the themes that I have here is that there's a very broad spectrum of individuals who are separating, divorcing, and indeed having children, never having cohabited. So if we look at society and say, what's happening when people separate? Many people are able to resolve their disputes without any professional involvement at all. And I should say, in some of those cases, and particularly if they weren't married, dad just disappears. I use that word metaphorically, but he just drops out. Mom doesn't seek support, or maybe she's getting support and it's being taken off his income, and he never sees the kids. Or in some cases, and there's research, a significant number of Canadians separate and don't have a separation agreement, don't even have any agreement at all. About 10% of Canadians who are separated, you ask what kind of, they say no agreement at all. And about another 25% say only an oral agreement. So when we think about the role of lawyers and mediators, that's a portion of the population. Now, from a public policy point of view, we're most concerned about the people going through the court system, but it's important to remember that there are those other people out there, and indeed, sometimes the situation of the children may be worse. They may be cases where there's been domestic violence, there may be mental health issues, drug addiction issues, and those children are very vulnerable. There are people who negotiate written agreements with lawyers, and those lawyers often have a mediative role. And I think family lawyers often get a bad reputation in that people say, oh, you go and see a family lawyer and the lawyers make things worse. In my sense and experience, yes, there are lawyers who crank up their clients, but by far more common is the lawyers telling the clients, be reasonable, think about your children, if we go to court, it's going to cost you a lot of money. And it's the client saying, no, I want justice. And really the response to that is, well, how much justice do you think you can afford? And it's the lawyer encouraging the people to be reasonable. And indeed, the two lawyers often will, in effect, be mediating the case. They'll be saying, they talk to each other and they're both actually persuading their clients to be reasonable. And that's a kind of mediation, or at least a mediative kind of role. And then we have parties who certainly go to formal mediation, and that's something we'll obviously be talking about. There's a role for judges as mediators, and I think a lot of mediation in this country is carried out by family court judges. Certainly, family court judges, one of the problems with family court judges and mediators is they're extremely expensive as mediators compared to other mediators, but they have certain values and position that may make them unfortunately necessary for some cases. And then we have cases where the judge actually makes an order. They actually go to trial and the court makes an order, but the people may still end up, the order may be for parenting coordination or post trial mediation. So mediation comes up in many places. Different people have a mediative role. I should say in many provinces, including Quebec, often, or at least in some cases, the child may have a lawyer. And in practice, often that lawyer is in effect a mediator, saying to the parents, I've talked to your child's number one message to you is settle this dispute. They don't want the conflict to go on. And some people will turn around as a result of that kind of intervention from the children's lawyer. When we talk about family mediation in a more formal way, so when people here identified or self-identified as mediators, and we don't actually have great national data, but in a study that Stats Canada did in 2011, they find about a third of the people said they consulted with lawyers and the lawyers settled the case. About 40%, somewhat more, said they went to court either with or without lawyers. And I should say, and again, we don't have great national data, but probably over 50% of people who go to court don't have a lawyer, go to family court, don't have a lawyer. And I should say one of the things about that is a lot of people, and so when people say 50% of people don't have lawyers, that's not quite accurate. It's 50% of people go to court. A lot of people have lawyers, don't go to court. In this study, only about 13% of people actually went to mediation. I think we've had an increase even since 2011, and I'll talk about this. We're seeing a lot more government funding for mediation or government access. We've probably had an increase since then. And 10% said they made agreements on their own. When we talk about mediation, there's open mediation and closed mediation, as I'm sure you're all aware. Increasingly at least in some parts of Ontario and elsewhere, we're having mediation arbitration or MED-ARB. Has everybody here has anyone who hasn't heard the expression MED-ARB? No, does it, some of you are saying, many of you do know what it is, some of you probably do it. The idea is that, and this is sort of an interesting process, and these are often people who are lawyers. The people have representation, and they go to a mediator arbitrator who say, I will try to mediate your dispute. And if I can't mediate, I will arbitrate, and I will make a decision. And I should say, so it's mediation with arbitration. And of course, what this does is it gives the mediator a lot of control over the process, saying, I'll hear you and see if I can help you come up with a dispute, come up with a resolution. If not, we'll have a bit of a hearing and I'll make a decision based on everything that I've heard. And of course, you only go to MED-ARB if you agree to it in advance. And what this in effect does is it gives the mediator a lot of leverage to come up with a resolution. And in that sense, it's actually quite similar to a judge at a case conference or settlement conference. You can't arbitrate in Quebec, not family arbitration. So in any event, you can't have MED-ARB in Quebec. But in most provinces, and I want to say it's not the most common way of resolving dispute. It's typically people have more resources, but MED-ARB is certainly something that happens a fair bit. And then we have the question about, what issues are being mediated? Are we talking about only child issues, only economic issues, all the issues? Who should be doing mediation? We'll come back and talk about that. And I think the answer is, depending on the nature of the case, different professionals can do the mediation. In terms of public policy issues, I've identified 3 public policy issues and 3 practice issues. There are, of course, more public policy issues, but my time is limited, and I'll just focus on 3 of them. And again, I'm giving a bit of an introduction here. I'm sure we'll talk about them more. One is, when we're talking about all these issues, is what's the role of research? And before I talk about the specific issues, there is a significant amount of research in this area, and then there's some nice literature reviews. I cite one of them here by Joan Kelly, where she reviews a lot of the literature. One of the problems with all family law research or social science research about family law cases is that it's very hard to do control group studies. Now, there are a couple of control group studies here. Bob Emery, who's going to be here, has done one. But it's very hard. I mean, the problem is if you say, well, and we did a study of, people who went to mediation, here were their outcomes, which are generally pretty positive. Those are people who chose to go to mediation. Or were sent there by their lawyers or whatever. So when we compare them to a group that went to court, often they're going to have better outcomes, but it's not necessarily because of mediation. It's associated maybe with who they are. It's the same kind of issue with joint custody. Often when research is done, people who have joint custody have better outcomes. It's not necessarily because they have better outcomes. it's not, they don't have better outcomes because they have joint custody. They have joint custody because they are better parents, more child focused, and that's why they have joint custody. Joint custody is a product, not a cause of the outcome. So we don't have, there is a problem and real limitations to the research. Having said that, generally speaking, people who go to mediation settle their cases at pretty high rates. I should say people go to court also settle their cases. We know that 2, 3, 4% of cases that go to court, that are starting the court process actually have a trial. But it seems that in general mediation is less expensive because cases are resolved more quickly. Having said that, there are undoubtedly cases where people try mediation, it doesn't work, and that just adds their legal bills. And there's questions about manipulation. It seems that people are more satisfied with mediation than going to court. They're more likely to be respected, or say they're more likely to be respected and heard. And there are a bunch of reasons for that. One is they're paying the mediator often, and the mediator is there to sort of listen to them, whereas a judge says, I'm here to make a decision. And interestingly, and perhaps most significantly, some of the research, and we certainly want more about this, suggests that children have better relationships with both parents, and typically here we're focusing on the non-custodial parent, if they've gone through mediation. That the relationship with the non-primary care parent is stronger if the parents have mediated than if they've gone to court. And to the extent that that can be replicated, that's, I think, a very important outcome. Interestingly and significantly, children do better. Parents, when you do longitudinal studies, they seem about the same in terms of their outcomes. And then it's important to recognize, as Joan Kelly emphasizes, that 15 or 20% of cases go to mediation, and no matter how you try, they're not going to settle. And to recognize that, and if we can identify those cases earlier, it will be better for everyone. So I think we certainly need more and better research. Having said that, the fact that we need more research, and one of the, I supervise a lot of students writing papers in family law, whether it's about custody or access or even economic outcomes, and typically the concluding paragraph is, we need more research. And I say, no, that's not a conclusion. That's just an observation that's always true. Actually, it's true about many, many issues. The reality is, whether you're a politician or a judge or a lawyer, you have to make decisions today with the information and research that we have. That's not a reason not to do more research, but we can't sit around and wait and say, until we have more research about mediation, we can't do it. Because not doing something is the same as doing something. So if we say, no, we need more research before we have mediation, well, that's like saying, well, then we don't need research about because we have the court system, and we have enough information about problems with the court system that we need to recognize that there's more use for mediation. And I should say, those of you who are familiar, and I know some of you are very familiar with this, in the last few years, we've had a number of reports about access to family justice. Sometimes it's called the Cromwell Report. It's actually a group of people, Jerry McHale, many others have been writing about access, improving access to family justice or improving access to civil justice. And one of the themes there very much is we need more use of mediation. And that certainly fits with this theme, even though we don't have all the research that we'd like to have. Now, one of the issues about mediation is it's an unregulated profession. In Canada, although there are places where there are, and Quebec in particular, there's certain kinds of regulations, anyone can say in most provinces that they're a family mediator. If you're going to actually, certainly in Ontario, if you want to cut somebody's hair and charge money for it, you have to be certified. If you want to help them resolve everything that's ever come up in their lives, all their economic matters, all their family and child matters, you can say you're a family mediator and have no training at all. So there are concerns about who is doing mediation, what is the competence of people who are doing it, what are their disciplines and ethics. Now, many people, and I suspect most, if not all of you in this room, who do mediation are part of a regulated profession, so there'll be some control. But there are people who are not part of regulated professions, and that's a concern. We don't know enough about, again, what the problems are, but it's certainly, in theory, a problem that it's an unregulated profession. And having said that, I think regulating, one of the reasons we don't have mediation as a regulated profession is there's so many different professionals who come at it in so many different ways. So lawyers who do mediation may approach it one way, social workers another way, psychologists another way. Can the government actually establish a regime of regulation? And I think that's one of the reasons why we don't see mediation being regulated. There's so many different professionals and they can't agree. And government says, this looks like a really messy problem. How are we going to resolve it? There's not an easy solution here. And in fact, to the extent that we have a solution, and I think it's going on really across Canada, government's saying we're not going to regulate, but we're going to subsidize certain people, and we'll make sure that they have, or hopefully make sure that they have qualifications. They may not always, but at least that's how we're regulating it, through subsidization. That being said, there's certainly needs for standards and accountability, issues about screening for domestic violence, and I should say just generally manipulation, alienation, high conflict, and ensuring that people who go through mediation have the opportunity for independent legal advice. That should certainly be part of any kind of regulation and something to be thinking about. There are, of course, professional organizations that have standards, and I think we'll be talking about that more over the next couple of days. In Ontario, we have the OAFM, Ontario Association of Family Mediators, Family Mediation Canada, that have standards and regulations for those who are prepared to be members. Most mediators, I think, in Canada, or most people actually doing this, are members of one of these organizations. And indeed, in Ontario, in order to be subsidized to get government funding, you have to have one of these certification standards. So we have, I think, de facto regulation, but not de jure in theory. One of the questions here is, to what extent should people be paying for mediation? To what extent should it be subsidized? To what extent should it be free? And increasingly, and I think wisely, governments are starting to subsidize mediation, have free access to mediation in different kinds of ways. And I think this is an area where there's probably, and Quebec again is a bit of a leader here, you have 5 free sessions of mediation. I understand, is that correct? Yes. So you have 6 altogether, the 1 information, the 5 free sessions. And I think that there's real value in some free access. Indeed, one of the concerns that I have is, if you're separating, you say, well, in Ontario, let's say, I'm going to have, actually, depending on the case, I may not get any free mediation, or depending on the situation. But if the one thing that, and if I go to see a lawyer, I have to pay the lawyer. If I go to a psychologist, I have to pay the psychologist. Is there anything that's free? Oh, yes, I can go to court. That's free, and the judge is free. Free to me, not free to society, and may not be the most useful way. So we're really subsidizing the wrong things. Having said that, I think that there's always an issue at some point about, it's a legitimate social thing to say, to what extent are we going to have people pay for the services they're using? And in particular, in this situation where you're going to have people who are very high conflict, personality disorder, they may really be using services a great deal. Now, from a social point of view, we can say there are innocent victims here, there are children, and we have to, as a society, be protecting their interests as well. So it's a question of balancing those concerns, but I think there's a place for both subsidization and for low-income people making it free, as much as we have family legal aid, and on the other hand, saying to people at some point, you're starting to consume a lot of these services, and we're going to have you pay for some of that as well. But that's certainly an issue we will talk about. There's a very controversial issue, mandatory mediation. In Australia, they have mandatory mediation, or theory they have mandatory mediation. They have family relationship centers. And I should say Australia has probably done more in terms of family law reform than any country, certainly in the English-speaking world. And they also do more research around family law. The government subsidizes research. And I think they've certainly decreased their use of courts by making more use of and having relatively either free and or subsidized mediation through the family relationship centers. That being said, even in Australia, we say, oh, they have mandatory mediation. Well, they say it's mandatory mediation, but there are ways that we will not make it mandatory, and particularly if there's domestic violence, but if someone doesn't show up, or if they have a good excuse to not mediate, they don't have to mediate. So it's mandatory unless. And let's say in Ontario, and to some extent I think across Canada, we're saying we're going to encourage you to mediate, but we won't have you do it. We're not going to make it mandatory. And I think those 2 ends of the spectrum kind of come together, and it may not be that different. If you have a lot of subsidies for mediation, it may be very close to the kind of model they have in Australia. In Canada, I mentioned we have increasingly mandatory or quasi-mandatory programs for parenting education around the separation process. I think that's incredibly valuable, although again, the research says, some people are more easily and effectively educated or changing their behavior than others. Some people are very unresponsive, and indeed the people who are most high conflict, most personality disorder, get the least out of education. And they hear about high conflict, that's the other person, and as opposed to reflecting on it themselves. In British Columbia, and we're going to hear more about British Columbia tomorrow, they have a model, I think, of encouraging mediation. They have a process of so-called notice to mediate. Once litigation has commenced, one party can, in effect, almost require the other party to attend mediation, or there may be consequences if they don't, but it certainly allows someone to encourage the other party to go to mediation. And also they have parenting coordination can be ordered by the court, mediation post-court. So they're moving towards a legal involvement in mediation in British Columbia, and I think that's something that we all want to be looking at. One of the issues about mediation, we talk about it, is people talk about it very generally, but of course there are different kinds of mediation. There's facilitative mediation, helping the people to resolve their disputes. There's evaluative mediation, where someone is in effect saying, this is what's likely to happen if you go to court. There's transformative mediation, and this is the idea that Howard Irving and others sort of said, well, we're going to help people to understand their problems and change their behavior. And indeed, one of the issues around research about mediation, people say, well, we have this mediation program, here's our success rate, and then one says, well, what kind of mediation is it? Is it evaluative? Is it transformative? Is it facilitative? That's often not teased out, and indeed, I think many mediators, in fact, are more what I would refer to as situational. They might do a little bit of all of them, and it depends on the nature of a case. But certainly when we think about mediation, what kind of mediation are we talking about? And what kind of education and training do we expect those who have mediation to undergo? And here again, as I've mentioned, the idea that judges, good family judges, are doing a lot of mediation in this country, and I think they have an incredibly important role as mediators. There are some cases that are not going to be mediated by someone who's not a judge. There are people who need the leverage of a judge, and including people who, we talk about evaluative mediation. There's nothing more, you may be a very knowledgeable family lawyer as a mediator, and you say, I think this is what's going to happen if you go to court, and the person says, what do you know? You're just a lawyer. But if a judge says, this is what I think is going to happen if you go down the hall to see one of my colleagues and have a trial, and we can either settle today or you can have a trial that's going to cost you $25,000, a lot of people will then say, maybe that mediator knows what they're doing. One of the concerns that I have as an educator is many people want to have training as mediators, but they can't get enough clinical work, enough good supervised clinical work to become certified as mediators. I think that's going to be an issue. How are you going to ensure that there's adequate training and education for those who want to be mediators? And is 100 hours, that's what's the OAFM standard, is 100 hours enough? When we think about what does it take to be an articling student, it's not 100 hours, it's about 2,000 hours. So those are things to think about as well. The final issue that I want to address is the issue of involving children. And some of you may know this is certainly an issue that is of particular concern to me. I've been doing research with Francine here, Francine Sear, and others, and writing about it. Children are at the heart of, in my view, should be at the heart of the family dispute resolution process, whether it's in court, being resolved through lawyers, or being resolved through mediation. They're the people who are experiencing the process. Now, how they should be involved is going to be difficult, and it's going to vary certainly with their age, and we want to be very careful not to have them forced to participate or not to feel they're forced to choose. On the other hand, at this point, too often they're completely ignored. And indeed, to go back to that spectrum, there's, I think, quite disturbing research about when people settle their cases on their own without involving any professionals, how few of them actually ask their children what they want or expect, and indeed how few of them even talk frank to their children. Just say, the child says, where's Dad? Dad's gone. That's it. No discussion, how do you feel about that as a child? So supporting children, listening to them through that process, I think, is very important. There's research from Australia and New Zealand, Jen McIntosh, but others, Goldston, have done research about child-inclusive or child-focused mediation, ensuring that the parents hear the child's voice. And indeed, I think any process involving dispute resolution is important for people to view how is the child perceiving this? And of course, that doesn't mean to say to the child, well, we want you to make the decision. We have an expression that it's giving the child a voice but not a choice. It's saying you should have some role in this. And typically, children will come back and say, not in all cases, but say, what I want is the conflict to end. And they might say, and I want to make sure my dog goes back and forth with me, or my hockey team is most important to me, or my ballet, or whatever. They have real interest, and the parents aren't hearing that at all. And the parents are interviewing the children on their own and saying, well, my child says they want me to be their parent. And they both say that. And the problem is, what's the child really thinking? And I think this is something that we increasingly have to be thinking about. Certainly the mediation profession increasingly has to think about, and there are different ways of dealing with it. There are models where a social worker meets with a child and discusses that with the mediator and the parents. There are cases, there's increasingly, I think, mediators are starting to meet with children, just as judges are starting to meet with children. Here in Quebec, and Quebec is a huge national leader on many issues, including on children meeting with judges. And although it's not appropriate in every case, I think it's appropriate more than we're doing it in the rest of Canada. And similarly, I think if judges are meeting with children, why aren't mediators meeting with children? So there's a role for children. It obviously has to be done in a very sensitive way. Children shouldn't feel that they're being pressured to participate, but at least they should be asked if they want to participate and think about how and when they might want to do that.